In the courthouse basement, there was a filing cabinet no one asked about. It stood against the far wall behind old tax ledgers and property maps, painted the same dull gray as everything else in the records room. Clerks rotated in and out over the years, but the cabinet remained. Its drawers were labeled in small handwriting, not case numbers, not dates, just street names. The town of Marlowe had fewer than 12,000 residents in 1978. It was the kind of place where zoning disputes were discussed in diners and where most legal conflicts ended in quiet settlements. At the center of it all sat Judge Harold Whitaker, appointed to the county bench in 1962 after a brief career as a property attorney. He was known for his patience. He rarely raised his voice. He believed, according to those who later spoke about him, that order depended on predictability. Stability, he would say, was the foundation of civic health. If you appreciate careful, documented reconstructions of overlooked history, consider subscribing. Stories like this are built from records most people never read. At first glance, Whitaker's career followed a conventional path. He presided over probate hearings, small claims disputes, zoning appeals, and the occasional criminal sentencing. He attended Rotary meetings. He wrote short editorials about civic responsibility in the local paper. There were no public scandals. But archived land records from Marlowe County tell a quieter story. Beginning in 1964, a limited liability holding company named H.W. Holdings began purchasing small residential parcels across town. The acquisitions were unremarkable individually: a duplex near the rail line, a vacant lot behind the elementary school, 3 adjacent storefronts on Elm Street.
The company listed no public manager. In court transcripts from the late 1960s, Whitaker often ruled on landlord-tenant disputes. Evictions were handled swiftly. He expressed concern about maintaining property standards. He cited municipal code with precision. Most defendants lacked representation. At the time, no one connected the rulings to the expanding portfolio of H.W. Holdings. Financial disclosure requirements for county judges were limited. Investments could be shielded through intermediaries. Corporate filings were stored in paper archives in a neighboring county, rarely reviewed unless litigation demanded it. What makes this case difficult is not secrecy in the theatrical sense. There were no hidden rooms or midnight exchanges. There were signatures, transfers, deeds notarized in daylight. Whitaker did not consider himself corrupt. In private correspondence recovered decades later, he described his purchases as protective consolidation. He believed fragmented ownership weakened towns. He believed central stewardship prevented decline. By 1975, H.W. Holdings controlled nearly 40% of Marlowe's rental properties. Most tenants did not know the ultimate owner. They knew only property managers and standardized notices. And in the courtroom above the basement records room, Judge Whitaker continued to preside over disputes involving properties he indirectly owned. The cabinet in the basement contained duplicate deeds, street by street. No one had yet opened all the drawers at once. The structure expanded gradually, without spectacle. Property transfers in Marlowe rarely drew attention. Homes changed hands through inheritance, divorce settlements, or quiet sales prompted by debt. By the early 1970s, economic pressure had begun to touch the town more visibly. A textile plant reduced its workforce. A feed mill closed after a regional merger. Mortgage delinquencies rose in small but steady increments. H.W. holdings appeared consistently in the aftermath. Foreclosure auctions were public but sparsely attended. Bidders were often the same 3 or 4 individuals. In archived attendance sheets, one name appears repeatedly as a proxy buyer. He was a local insurance broker with no obvious connection to the court. Deeds transferred through his name for several weeks before being reassigned to the holding company. None of this violated statute. Judge Whitaker had once practiced real estate law. He understood the vulnerabilities in property cycles. In a letter to a former law school colleague, he wrote that municipalities suffered when ownership becomes sentimental rather than strategic. The phrasing suggests a framework. He saw consolidation not as extraction, but as insulation against decline. In court, his language shifted subtly over time. During code enforcement hearings, he began emphasizing compliance timelines with greater rigidity. Extensions became shorter. Fines accumulated more quickly. When small landlords failed to meet repair standards, liens were placed on their properties. Several of those liens were later satisfied through sale to H.W. Holdings. Publicly, Whitaker spoke about revitalization. He supported stricter zoning interpretations. He cited fire safety. He referenced neighborhood continuity. On record, his rulings were defensible. Appeals were rare. Most residents lacked resources to pursue them at the state level.
The town council, dependent on property tax stability, saw few reasons to object. Rental units were maintained. Vacant lots were cleared. Revenue remained predictable. Yet beneath the surface, the dynamic shifted. Tenants began noticing uniform lease agreements across unrelated addresses. Maintenance crews rotated between properties that, on paper, were owned by different entities. Rent adjustments followed similar schedules. There was no announcement of a centralized authority. It emerged through paperwork. One former clerk, interviewed years later, recalled preparing eviction files that felt repetitive in tone. The petitions cited identical phrasing. The plaintiffs were technically different companies, though registered agents often shared mailing addresses. Whitaker continued to recuse himself from cases only when a direct ownership line could be easily traced. Indirect holdings were not addressed. Disclosure standards did not require deeper explanation. The holding company's map of Marlowe grew denser. Not contiguous blocks, but strategic corridors, streets near the courthouse, properties adjacent to planned infrastructure improvements, parcels bordering commercial zones. Ownership, when viewed individually, seemed ordinary. Viewed collectively, it formed a pattern that few had reason or access to fully assemble.
Control rarely announces itself. It settles into procedure. By the late 1970s, Marlowe's housing market no longer behaved like a collection of private decisions. Rent levels adjusted in near unison across neighborhoods that had once differed in price and condition. Lease renewals arrived with standardized clauses referencing municipal code sections that few tenants had read. Late fees were calibrated with precision. The town's banks had also become quieter participants. 2 local lenders began tightening underwriting standards for small property investors. Loan officers cited risk exposure and market instability. Applicants seeking to purchase duplexes or storefront buildings were often denied financing unless they could demonstrate unusually high liquidity. In several instances, rejected properties were later acquired by subsidiaries linked to H.W. Holdings. No document connects these decisions directly to the judge. But board minutes from First County Savings show that Whitaker attended at least 3 advisory meetings as a civic liaison. His presence was framed as ceremonial. Still, his legal expertise carried weight. Whitaker believed fragmentation produced disorder. That idea appears repeatedly in his private notes. He wrote about towns losing coherence when decision-making authority diffuses beyond competence. To him, consolidation was not greed, it was structural hygiene. Inside the courthouse, docket management became more streamlined. Landlord-tenant cases were grouped by property type. Hearings moved quickly. Defendants often stood alone before the bench. Whitaker listened carefully, but rarely deviated from statutory language.
What shifted was not the letter of the law, but its rhythm. Repair violations cited by code enforcement officers increased in frequency for independent landlords. Inspections became more systematic. Fines were levied with consistency. When payment plans faltered, properties entered receivership. Receivership frequently ended in sale. The town council approved a redevelopment corridor near the rail line. Infrastructure funds were allocated to improve lighting and drainage. Several parcels within the corridor had already been acquired by entities tied to HW Holdings. Public investment elevated private value. Again, nothing on record breached explicit legal boundaries. But residents began noticing narrower options. Small landlords found it harder to remain solvent. Tenants discovered that moving across town did not significantly alter lease terms. Commercial renters negotiating storefront contracts encountered uniform conditions, even when dealing with different property managers. Ownership was diffused across paperwork, yet centralized in effect. Whitaker did not conceal his philosophy. In a 1979 civic address, he stated that stability requires stewardship, and stewardship requires capacity. He framed concentrated property management as a safeguard against economic decay. Applause followed. The system did not depend on intimidation. It relied on alignment of banks, inspectors, and municipal priorities. By 1980, more than half of Marlowe's rental housing traced back through layered corporations to a single network. The cabinet in the basement continued to receive new entries. Streets were added, not in clusters, but incrementally. Each drawer represented a geography of quiet influence. Few people had reason to examine how many drawers there were.
The first formal question did not come from a journalist or a political rival. It came from a title examiner. In 1981, a young attorney named Daniel Mercer was hired by an out-of-state development firm considering entry into Marlowe's commercial market. His task was routine: trace ownership histories on a series of storefront properties along Elm and Carter Streets. The firm wanted clarity before committing capital. Mercer began assembling chains of titles from county archives. The records were complete but layered. Parcels transferred between limited partnerships, then into trusts, then reassigned through warranty deeds that appeared administratively separate. The names shifted. The mailing addresses, however, often converged. He noticed that several entities shared a post office box registered to a small accounting office 2 towns over. The office listed multiple corporate clients, but its filings were managed by a single attorney who had once clerked in Whitaker's courtroom. None of this was illegal, it was simply dense. Mercer requested additional documentation from the county recorder. The staff complied. The transactions had been properly notarized, taxes were paid, liens were cleared in sequence, there were no missing signatures. What unsettled him was the repetition of legal phrasing across corporate charters. The language bore stylistic similarities to opinions Whitaker had written early in his judicial career before appointment to the bench. It was not identical, but the cadence was familiar. Mercer prepared a memorandum for his client, noting high consolidation risk and limited competitive availability. The development firm withdrew its interest. Around the same time, a school board proposal to expand a vocational training facility stalled. The expansion required purchase of adjacent lots. Negotiations proved difficult. Asking prices rose unexpectedly. The parcels were technically owned by different holding groups. Coordination among them was precise. Whitaker did not participate in school board deliberations. Publicly, he remained outside municipal planning decisions. Privately, correspondence later recovered indicates he monitored zoning adjustments closely. He viewed institutional growth as beneficial, but only when it aligned with long-term property stability. There was no overt resistance in town. Most residents experienced the system as administrative consistency. Leases renewed, taxes were assessed, hearings were conducted on schedule. Yet mobility narrowed further. Independent business owners seeking to expand found limited storefront supply. Prospective homeowners competing at foreclosure auctions encountered familiar bidders. Rental applicants discovered uniform screening criteria. Mercer considered raising concerns with the State Bar Association but hesitated. He lacked proof of direct judicial conflict. Financial disclosures, though minimal, had been filed according to statute. The web was visible but not conclusively attributable. What he had found was not a single violation. It was architecture. And architecture, when legally assembled, rarely draws immediate alarm. Pressure did not erupt, it accumulated. In 1982, a maintenance worker named Louis Andrade filed a complaint with the county housing office. He alleged that multiple properties managed by separate companies were deferring structural repairs while issuing synchronized rent increases. Andrade had worked across several of those buildings. He believed the coordination suggested a common direction. The complaint triggered a review, though not an investigation in the criminal sense. Inspectors revisited the cited addresses. Minor violations were recorded, compliance notices were issued, deadlines were met within the required window. On paper, the system functioned. Andrade persisted. He began collecting copies of lease agreements from tenants who were willing to share them. The clauses were nearly identical in formatting and legal terminology. He highlighted sections referencing arbitration procedures that routed disputes away from local courts and into private mediation panels administered by firms outside the county. Such clauses were lawful, increasingly common in commercial practice. When a group of tenants attempted to challenge fee escalations collectively, they encountered procedural fragmentation. Because each building was technically owned by a different entity, the claims could not be consolidated easily. Separate filings required separate counsel. Few could afford that. Judge Whitaker did not preside over arbitration matters. He had, however, publicly advocated for alternative dispute mechanisms as a way to reduce judicial backlog. In speeches archived by the Marlowe Civic Association, he described arbitration as efficient and less adversarial. Efficiency, in his framework, equaled order. Around this time, Whitaker's nephew, recently graduated from business school, relocated to the region. Corporate filings show he assumed managerial roles in two intermediary holding companies tied to H.W. Holdings. The transition appeared procedural. Family involvement in property management was not unusual in small towns. Still, the network tightened. A local newspaper columnist published a brief editorial questioning rising rents despite stable maintenance costs. The piece avoided direct accusation. It referenced concentrated ownership patterns without naming individuals. Within weeks, the columnist accepted a position in another city. There is no documented connection between his departure and external pressure. Meanwhile, property assessments were adjusted upward following infrastructure improvements. Tax burdens increased for independent homeowners, while large holding groups leveraged depreciation structures to offset exposure. The disparity was technical, embedded in accounting. Whitaker continued issuing rulings with measured tone. His written opinions emphasized statutory interpretation and civic continuity. Colleagues described him as consistent. Consistency can resemble neutrality. By late 1983, more residents sensed constraint but struggled to articulate its source. Choices appeared available in theory. In practice, they circled back to the same corporate network. The system did not need to coerce, it only needed to structure the field in which decisions were made. And in Marlowe, that field had become increasingly narrow.
The shift toward exposure began outside the county. In 1984, the State Judicial Ethics Commission initiated a routine review of financial disclosure compliance across several districts. The audit was not targeted. It was part of a broader modernization effort following amendments to reporting standards. Judges were required to provide expanded summaries of beneficial interests held through trusts and limited partnerships. Whitaker submitted his forms on time. What changed was the definition of beneficial. Under the revised guidelines, indirect control through layered corporate structures required fuller explanation. The Commission requested supplementary documentation from a small number of judges whose filings contained ambiguities. Whitaker's name appeared on that list. The request was procedural. It did not allege misconduct. It asked for clarification regarding certain real estate interests referenced but not itemized. Whitaker responded with a memorandum drafted in precise language. He described his role as a passive investor in diversified property assets managed independently. He emphasized that operational decisions were delegated. He affirmed that he recused himself when direct conflicts were apparent. The Commission reviewed the materials. On their own, the documents complied with existing disclosure thresholds. But cross-referencing began to reveal patterns. State analysts compared corporate registrations, trust beneficiaries, and property tax records. The overlaps were not hidden, they were simply dispersed across filings maintained by separate agencies. When aggregated, the concentration was substantial. Meanwhile, in Marlowe, tenant turnover increased. Rent adjustments outpaced wage growth at the remaining manufacturing plant. A handful of small businesses closed after lease renegotiations failed. Vacant storefronts were renovated quickly and reintroduced at higher rates. Whitaker framed these developments as market correction. In a private meeting with 2 county commissioners, he argued that disciplined property management would attract external investment. He cited declining rural towns as cautionary examples. Fragmented ownership, he maintained, prevented coordinated improvement. His reasoning was consistent with his earlier philosophy. He did not see accumulation as domination. He saw it as stewardship, exercised by someone competent enough to implement it. Back at the state level, the Ethics Commission debated jurisdictional limits. Ownership itself was not prohibited.
The concerns centered on whether judicial authority had intersected materially with financial expansion. There was no single ruling that established direct enrichment. Instead, there were sequences: code enforcement strictness preceding acquisitions, receiverships resolving into corporate transfers, advisory roles at financial institutions that financed purchases later appearing in court, individually defensible actions, collectively significant. The Commission voted to conduct a preliminary inquiry. Notification arrived at the courthouse in a sealed envelope. Whitaker read it in chambers, alone. There is no record of his immediate reaction. Only later that afternoon he presided over a scheduled eviction hearing with his usual composure. The architecture he had constructed was now being examined not street by street, but as a whole. The inquiry advanced quietly. 2 investigators from the State Commission arrived in Marlowe without public announcement. They requested access to archived case files involving receiverships, landlord-tenant rulings, and municipal code enforcement appeals spanning 2 decades. Court staff complied. The materials were boxed and logged. The investigators did not begin with accusation. They constructed timelines. They noted instances where independent landlords faced accelerated compliance deadlines, followed by liens, then foreclosure sales in which proxy bidders participated. They compared those timelines with subsequent property transfers into holding entities connected through layered registrations. The pattern was not mechanical. There were variations. Some properties passed through intermediate owners for years before consolidation. Others entered the network within weeks. What concerned the investigators was proximity, administrative action preceding financial opportunity. Whitaker retained counsel. In correspondence preserved in Commission archives, his attorney argued that correlation did not establish causation. Judges interpret law. Markets respond independently. The letter emphasized that Marlowe's economic shifts mirrored broader regional trends. Industrial contraction, rising insurance costs, and demographic stagnation were cited as explanatory variables. The argument was not implausible. Public awareness remained limited until a procedural filing became accessible through state records. A regional newspaper published a short article referencing an ethics review of a county judge for potential disclosure irregularities. The piece did not elaborate. Within days, speculation circulated. Town meetings grew more restrained. Conversations in commercial corridors became measured. Some residents expressed disbelief. Others described long-standing unease without having articulated it. Whitaker continued reporting to the bench. His courtroom demeanor did not change. Transcripts from this period show careful attention to statutory citation. He avoided commentary beyond what was necessary to render decisions. Privately, he drafted a statement asserting that his investments had preserved housing quality and prevented absentee ownership by distant corporations. He framed himself as a local guardian against external exploitation. In one recorded interview conducted later, Whitaker reflected that concentration of assets under responsible oversight prevented blight. He viewed himself not as a profiteer, but as a stabilizer operating within legal parameters available to any qualified individual. The Commission's review expanded to include banking communications. Advisory meeting notes were subpoenaed. Though informal, they revealed discussions about tightening lending criteria during periods when acquisitions accelerated. Again, no explicit directive linked judicial authority to credit policy. Influence is rarely documented in command form. As scrutiny intensified, several intermediary corporations dissolved voluntarily.
Assets were reassigned into simplified structures. The timing drew attention. For the first time in 2 decades, the network showed signs of adjustment under observation. The town, long accustomed to administrative predictability, now faced uncertainty not about housing supply, but about governance itself.
Formal hearings were scheduled in the state capitol in early 1985. They were administrative proceedings, not criminal trials. The question before the panel was narrower: whether Judge Harold Whitaker's financial interests, disclosed or otherwise, had created a sustained conflict with his judicial responsibilities. Testimony unfolded without spectacle. Commission counsel presented compiled property maps showing cumulative acquisition over time. The visual impact was restrained but clear. Streets once owned by unrelated parties had, over 2 decades, converged into a small cluster of beneficial entities. Case summaries were introduced to demonstrate instances in which judicial rulings preceded ownership transitions that ultimately favored those entities. Whitaker's attorney responded with procedural arguments. Each ruling, he maintained, relied on statutory authority. Code enforcement actions were initiated by municipal officers, not the court. Foreclosures were conducted according to state law. Purchases at auction were open to any bidder. Whitaker himself spoke briefly. He did not deny investment. He described it as long-term civic participation. He explained that declining rural markets required decisive stewardship. Fragmentation, he argued, discouraged maintenance and invited speculative neglect. He believed that coordinated ownership ensured consistent standards and preserved tax stability. When asked whether he saw any ethical tension in presiding over disputes within a housing market in which he held significant interests, he paused before answering.
He stated that he had recused himself when direct ownership was apparent. He acknowledged that indirect relationships, viewed collectively, might appear expansive in hindsight. But at each moment, he had evaluated conflicts individually. The law did not require broader aggregation. The panel examined disclosure forms submitted over the years. Earlier filings referenced diversified real estate holdings without itemization. Later amendments contained more detail, though still filtered through holding structures. Compliance with technical requirements was difficult to dispute. The concern centered on spirit rather than letter. Witnesses from Marlowe testified about market conditions. Some described improved building maintenance. Others recounted limited bargaining power and rising rents. None alleged overt coercion. Most framed their experiences as structural. After several days, the Commission issued preliminary findings. They concluded that while no single ruling constituted explicit self-dealing, the cumulative scale of Whitaker's property interests created an appearance of pervasive conflict inconsistent with judicial impartiality. The language was careful. They recommended suspension pending further review and referred certain financial disclosures to the State Attorney General for examination under revised reporting statutes. Whitaker returned to Marlowe without comment. Within weeks, he submitted a letter of retirement, effective immediately. He cited health considerations. The courthouse calendar was reassigned to a visiting judge. Ownership records, however, did not dissolve with his departure. The network remained in place, its structure intact, though now subject to heightened attention.
Marlowe did not collapse. It continued operating, but under a different awareness.
After Whitaker's retirement, the question facing Marlowe was not whether laws had been broken, it was whether trust had been narrowed. The State Attorney General's office reviewed financial disclosures under the updated statutes. The analysis focused on reporting thresholds and beneficial interest definitions rather than moral judgment. Ultimately, no criminal indictment was issued. Certain filings were deemed incomplete by contemporary standards but consistent with earlier regulatory interpretations. Administrative penalties were considered and then set aside in light of statutory ambiguity. The legal outcome was restrained. What changed more visibly was governance. The county adopted expanded disclosure requirements for judicial officers and senior municipal officials. Beneficial ownership through layered entities now required detailed reporting. Recusal standards were broadened to include aggregated financial exposure within a jurisdiction's housing market. These reforms were procedural. They did not dismantle property networks already in place. H.W. Holdings underwent restructuring. Several assets were divested to regional investment groups. Others were retained under simplified ownership. Rent schedules stabilized for a period as new management reassessed portfolio strategy. The market diversified slowly, though concentration remained higher than in comparable towns. Whitaker lived quietly after leaving the bench. In a recorded interview conducted years later for a local historical archive, he reflected on his tenure without defensiveness. He maintained that his actions had prevented deterioration. He acknowledged that scale altered perception. If he had erred, he suggested, it was in underestimating how cumulative influence appears when viewed in total. He did not describe himself as wrong. He described himself as misunderstood within evolving standards. For residents, the experience lingered less as outrage and more as recalibration. They had witnessed how authority, exercised consistently and within formal boundaries, could shape economic terrain without overt violation. The system had not relied on secrecy in the dramatic sense. It relied on dispersion, of paperwork, of responsibility, of interpretation. Marlowe's streets did not change overnight. Buildings remained, storefronts reopened, families renewed leases, yet awareness persisted that governance is not only about explicit decisions, but about the environment in which choices are structured. The archive boxes from the ethics inquiry were eventually cataloged and stored at the state level. Researchers who examine them today encounter no single document that explains everything. Instead, they find sequences, timelines, filings, meeting notes that reveal how influence can accumulate quietly under lawful cover. The story of Judge Harold Whitaker does not end with conviction or exoneration. It rests in the tension between legality and legitimacy. Institutions depend on more than compliance. They depend on the perception that power is exercised without personal architecture behind it. In Marlowe, that perception had to be rebuilt, document by document. Years after the hearings concluded, Marlowe's transformation was easier to chart on paper than to feel on the ground. Economic data showed gradual diversification of ownership. A regional housing cooperative acquired several mid-sized complexes. 2 storefront blocks were purchased by a credit union consortium. Independent landlords re-entered the market, though cautiously. On spreadsheets, concentration ratios declined. Yet structural memory persisted. Residents who had once attempted to negotiate rent recalled how limited their options had seemed. Small investors who had abandoned bids at auction remembered the familiarity of competing faces. Even without overt instruction, patterns had shaped expectations. People learned where not to try. Institutional adjustments cannot immediately erase learned restraint. A visiting sociologist from a state university conducted interviews in 1992 as part of a broader study on rural governance. Participants rarely described Whitaker as malicious. Many used words like disciplined, intelligent, committed. What unsettled them was scale. They had not realized how much of the town's physical framework traced back to one interpretive center. The authority had not announced ownership. Ownership moved alongside authority. The sociologist concluded that Marlowe represented a case of procedural enclosure, not enclosure by force, but by layered compliance. Each action remained within defined boundaries. Together, they redirected opportunities. Whitaker died in the late 1990s. His obituary emphasized decades of public service. It mentioned his contributions to housing stability. It did not reference the ethics proceedings. Public memory, like property records, is selective.
The buildings he accumulated still stand. Some have been renovated beyond recognition. Others retain their original brick facades. Tenants change. Business names rotate. The street grid remains. What endures is less visible. The episode altered how subsequent judges approached disclosure. It influenced municipal debate around procurement and advisory roles. It sharpened awareness that civic language, stability, stewardship, order can mask asymmetry when left unexamined. Marlowe did not become cynical. It became attentive. There is no dramatic ruin in this story, no abrupt collapse. The town continued functioning before, during, and after consolidation. That continuity is part of what made the system effective. Power rarely needs spectacle to reshape a landscape. It requires patience, access to process, and a belief, often sincere, that concentrated judgment serves the collective good. Judge Whitaker believed he was preventing decline. The record suggests he also narrowed the field through which others could shape the town. In the end, the lesson is not about a single man's ambition. It is about how institutions can be navigated in ways that remain technically lawful while altering the balance of civic life. If you value documented reconstructions of quiet institutional power like this, consider subscribing for more.